Hello, everybody. I am Oscar Gomez. I'm the Senior Litigation Associate here at EPGD Law. I'm filling in for Eric today on our Facebook Live. And today our topic is buy-sell agreements. Buy-sell agreements are very important tools for business owners in Florida and even more important in other states. So I'm just going to talk a little bit about what a buy-sell agreement is, why you want one if you're a business owner, what the benefits are, and also a little bit about what events are triggered in a buy-sell agreement. So first off, what is a buy-sell agreement? It's neither a buy or sell agreement. Basically what it is a buyout agreement for business partners. So you have any kind of business venture that you have, let's just take an example, two partners. What a buy-sell agreement would do is it would lock in the terms of a potential buyout of one of those partners in the event of a partner death, partner, I have here five or six basically occurrences where it would come into play. One would be death of a partner. Two would be disqualification of a shareholder from the practice of whatever type of business it is. It could be an accounting firm, it could be a law firm. So if one of the partners gets disqualified, it would come into play when that happens as well. Permanent disability or incapacity to work of one of the shareholders or partners would be another one. Complete cessation of employment of the partner, or even personal bankruptcy of one of the partners. So any of those events happen, and basically that would trigger the buy-sell agreement. So what does a buy-sell agreement do? Basically what the buy-sell agreement does is it says, listen, one of these things happens, the partner can't work for whatever reason, the other partner will be able to purchase his shares in the entity, in the business entity. And it'll be for a set price, which is set in the buy-sell agreement. And really the main function of it is to keep the business going uninterrupted. I have seen situations where you have two partners in a business, no buy-sell agreement, and what ends up happening is one of the partners dies, and they were best friends, and they started this business together. So one partner dies, the other one is obviously very sad because he's lost his best friend and his partner. Come to find out that his partner had been skimming money from the business for the 6 months prior to his death. So there was about $60,000 to $80,000 that were unaccounted for in the business. So the other partner had no buy-sell agreement. So at this point, he had to negotiate the sale of the other partner's shares with the deceased member's spouse. And somehow he had to figure out a way to bring up the fact that her husband was skimming money from the business for 6 months prior to his death. So if that conversation wasn't uncomfortable enough, it gives leverage to the spouse because, she doesn't have to sell her shares if there's no buy-sell agreement. She could keep them, she could leverage them into getting a better deal for, the money that was skimmed from the business. She could have it forgiven. She could use that as leverage with the other partner. That situation I'm speaking of is still unresolved, but it's just one example of things that can happen when you do not protect yourself in a business venture. It becomes all the more important the longer the business venture has been going and the more lucrative the business venture is. So the more value that's added per year that you're not protecting yourself, the more harmful it can be. So I'm just going to talk a little bit right now about the benefits of buy-sell agreements. So I wrote them up here. Basically, first benefit, it guarantees the heirs of the business owner assets they may not know how to manage. So basically what that means is there's a set price in the buy-sell agreement for how much partner A, who is, let's say he passes away, his son or his wife or whoever his heirs are, it guarantees them a set price for that partner's shares in the business. So let's say a partner in a law firm passes away, his shares are worth $100,000. that guarantees the family an immediate $100,000 triggered upon a date set in the buy-sell agreement, which will usually be about 60 to 90 days after the occurrence of the death, which the other partners or partner will have to pay them. So it gives them it gives them money basically for something. The son is not sophisticated. He's not a lawyer. Maybe he has no use for having partnership interests or having a membership interest in the entity. So it guarantees him income for his father's involvement in his father's interest in the business. The second and probably the most important benefit that I already touched on was the business can continue. The biggest problem when there's no buy-sell agreement is the actual function of the business is interrupted. The partners, basically, the remaining partners or partner, have to figure everything out that they didn't figure out beforehand by doing an agreement. So when somebody dies or when somebody can no longer work, they have to resolve all the issues. So basically, when you have an agreement in place, the business can continue uninterrupted, unaffected, and the other partner can move forward. So that's really the most important one. Then you also have partners themselves. The remaining partners are protected from unsophisticated heirs. It's similar to the one I said before, but it's a protection to the remaining partners because you don't necessarily want to deal with idiot sons or other heirs who may not have great intentions, which is definitely a problem. The transfer of wealth is smooth, like I discussed. In a buy-sell agreement, there's going to be an exact date. So let's say one of the partners is incapacitated. Within 90 days of that occurrence is going to trigger the buyout. So it's a smooth transfer. There's no litigation involved, no application to the courts. All those things can always occur despite having a buy-sell agreement because they could be challenged. But this just makes it far more unlikely that you're going to end up there. You can fund a partner withdrawal or death. Basically, on top of being able to have a buyout price, another common thing to do with buy-sell agreements is you can fund them with life insurance. So if there's a life insurance policy on one of the partners, that can fund the actual buy-sell agreement. The actual terms of that is beyond the scope of this Facebook Live, but it is definitely an option, and it is very common, and it's something that we do and we have discussed with financial professionals who we work with, and it's a very popular mechanism. Lastly, some states, not Florida where we live, but in other states, the spouse in a divorce can actually take business assets. So shares, let's say a partner owns 50%, he's involved in a messy divorce, his spouse can ask the court for half of that. So she can basically petition the court for half of that. Even in states like Florida, that can happen. It's more unlikely because of the family laws in Florida. It's more unlikely, but it can happen. When buy-sell agreements are in place, when mechanisms are in place, you can even make divorce one of the mechanisms upon which it'll be triggered. So there's just a lot of creative things you could do there to protect yourself with buy-sell agreements. We basically encourage it. If every dollar spent on a buy-sell agreement or something of the nature to protect yourself beforehand is going to save you $10 on the back end, and it's going to give you a lot of peace of mind going forward in your business. But like I said, the longer the business has been active and running and in good shape, the more you need it. I'd like to thank everybody for joining us on today's Facebook Live. If you have any questions regarding buy-sell agreements, you can contact us here at the firm. You can call us, email us, contact us through our website, and we would be happy to help with all your needs.